This is my observation and the ruling. This court has carefully listened to counsel in mitigation. It appears that there is a historical financial problem at the university that has now reached a level where members of staff are not receiving their agreed salaries and allowances in accordance with the law. As the court noted in the ruling that we delivered yesterday on contempt, deferment of salaries is illegal and unconstitutional. As noted, the respondents are not helpless and there are avenues available for the respondents to get out of this in law. Except for 2 letters written to the ministry after the court order of 30th May 2022, there is no effort made by the respondents to sort out this issue. Why haven't the respondents engaged members of the claimant to have an amicable solution? Why haven't the respondents engaged the ministry directly beyond the letters? What efforts have been made to that end? The court is of the view that the respondents have taken this matter casually in total disregard of the welfare of the members of the claimant who go to work each day to do their work. In return, they are unable to meet their financial obligations because they only receive a percentage of the agreed pay. Whether 57% or 68%, the deduction or deferment of the pay, as the court has said, is illegal and unconstitutional. Members of the second respondent, along with the third respondent, have not demonstrated good efforts in honoring the court order. In fact, the conduct of some of the respondents or members of the second respondent is contemptuous and casual to this very moment, as they have, for example, refused to appear in court even after being present yesterday, and the court has issued warrants for their arrest. This court is not interested in punishing the respondents for the sake of it. I wish I was informed today that the contempt has been purged or that an agreement has been reached between the claimant and the respondents. Instead of putting efforts towards purging the contempt, the respondents have engaged in making one application after another. While that is their right, I think it would be more productive and meaningful if they engaged with the same gusto towards resolving the issue before court. While the court has listened carefully to the mitigation offered, I note that some of the documents now brought to court ought to have been tendered in evidence. Why were they not availed as evidence? The answer is that the respondents, in my view, have been very casual in their approach in this matter. The respondents have deliberately disobeyed a lawful court order, and as much as this court has carefully listened to the mitigation, there is need to stamp the authority of the court to set precedent that court orders shall not be ignored or violated without consequences. In the circumstances, and taking into account the mitigation offered, each of the members of the second respondent and the third respondent are each fined Kenya shillings 100,000 or in default to suffer 30 days imprisonment. The first respondent can only act through the respondents, and as such, it is spared of the fine or the imprisonment, being a juridical person. The respondents shall have no audience in this court unless and until they purge the contempt. Of course, future applications for continued contempt may be filed and dealt with on merit. Once arrested, those members of the second respondent shall be brought before this court for an appropriate action over and above them meeting the fine and or the imprisonment that has been, for the reasons that have been said, have been given by Counsel Konosi and the team. We still hold you with high esteem and regard, members of council. You are people, you are the cream of this society, and we don't want to subject you to indignity. You can see we have some 4 police officers who have been sitting here, who have been actually standing throughout the proceedings for the sole number of hours. So I'll tell them, officers, who is in charge? What's your name, sir? Yes, Sergeant, hold these people here in this court as they sort out and decide whether they pay the fine or they want to go to jail. If they don't do so by 5 p.m., then they might have to spend a night in custody, which is not a very good thing. So kindly, members of the council, do the needful and sort out this matter. And I'm not enjoying, actually, I've not enjoyed even reading this ruling, because it's not the way we are supposed to be working. Because some of you will even go with very, very sour taste, saying that that judge is not a good person. How can he imprison? You know? But we have to enforce court orders, and something has to be done. We cannot say that this issue of salaries is so huge that it cannot be resolved. You are not helpless, as I have said. And I must say this, even if it may, is probably as unpleasant as it might sound. Even you people, if you cannot get a solution to this, do the honorable thing. Others will come and try to resolve it, isn't it? Dr. Aluario, yes. Isn't that the case? Even me, if I'm unable completely to